You used to be the person people called when no one else would pick up, not a hotline. You personally? Your cell number was on flyers at community centers in 3 counties, a small practice out of a converted storefront, one paralegal, a printer that jammed twice a day, a waiting room with more people than chairs. You took plaintiff cases, environmental contamination, workplace injuries, wrongful terminations, against companies with legal departments bigger than your entire building. You won more than you lost. That was the thing that made the flyers work. One case defined you, at least in your own mind. A manufacturing plant had been venting improperly for 6 years. The neighborhood had elevated rates of a specific respiratory illness. The company's internal memos showed they knew. You spent 2 years on it. The settlement wasn't what you asked for. It never is. But it was enough to relocate 11 families and fund a 10-year medical monitoring program. You framed the check. Not the amount. Just the check itself, made out to the trust. It hung above your desk for years. Then a senior partner at a large firm called. He said your litigation instincts were exceptional and being wasted on cases that couldn't sustain you long-term. He wasn't wrong about the sustaining part. You were $41,000 in personal debt. Your paralegal hadn't had a raise in 2 years. He offered partnership track. Plaintiff side work, he said. Complex litigation, resources, staff, a research budget. You would fight bigger fights and win them more often. You told yourself outcomes were what mattered, that you could do more good with a functioning infrastructure than a jammed printer. You accepted. The first year was mostly what they promised. A pharmaceutical case, a class action involving data privacy, one environmental matter not unlike your old work. You were in federal court. You had associates doing the document review you used to do yourself at midnight. Then the senior partner came to you with a conflict question. The firm had been approached by a petrochemical company facing a contamination suit. He wanted your read on whether the plaintiff's scientific evidence had the weaknesses he thought it did. You read the file over a weekend. The science was legitimate but imperfect. Causation was arguable. You told him exactly that. 6 weeks later, the firm had taken the defense representation. Your analysis had structured their initial motion strategy. Nobody asked you directly. Nobody needed to. You had given them what they needed in the form of a clean, deniable professional opinion. You went to the partner, said you were uncomfortable. He listened carefully. Said you were right to raise it. Said the firm would be more careful about compartmentalization. Said your discomfort showed exactly the kind of ethical instinct that made you valuable. You left his office feeling managed. You were right. You had been. 2 years later, you were a full partner. The plaintiff work was still there, but thinner. The firm's largest clients were corporations, and corporations needed counsel on both sides of their exposure. The distinction, you had been taught to tell yourself, was legally legitimate. Both sides deserved representation. The adversarial system required it. You believed that. You also noticed that defense cases paid 3 times what plaintiff cases did, and that plaintiff cases were the ones increasingly declined at intake. There was a young woman on the other side of a case that year, a former employee of a logistics company, alleging systematic wage theft across a workforce of several thousand. The math was clean. The documents were strong. She had an attorney from a small firm, young, underfunded, clearly working the case on contingency. You recognized the situation immediately because you had been in it. Your client's position was that the pay classifications were legally defensible. They were. Technically. You filed motions that were procedurally correct and designed to exhaust the opposing counsel's resources before trial. You knew what you were doing. You knew the case would likely settle for a fraction of what the workers were owed, not because the law required it, but because the other side couldn't sustain the fight. It settled. The workers got 32 cents on the dollar. You didn't go back to look at the number. You knew better than to go back and look at the number. Then a man began appearing. Not at your firm, at events, industry conferences, bar association dinners, a judicial fundraiser you attended because your managing partner asked you to. He was always introduced differently. Sometimes as a consultant, sometimes as a policy advisor, sometimes vaguely as someone who worked across sectors. He was never loud. He remembered details. The second time you met him, he mentioned something you had said at a panel 8 months earlier, precisely and without effort. He suggested lunch. You went. He said he worked with several of the firm's largest clients on matters that required a specific kind of legal coordination, situations where regulatory outcomes and litigation strategy needed to align, where the right relationships with the right people at the right agencies made the difference between a case that resolved quietly and one that became a problem. He said your profile was exactly what certain matters needed. You asked what kind of coordination. He smiled. The kind, he said, that stays off the record. You told him you weren't interested in anything off the record. He said he understood completely, said there was no pressure, said he'd enjoyed the conversation. He handed you a card, plain, just a name and a number. You kept it in the inside pocket of the jacket you wore most often. You told yourself you kept it to know who he was. You know now that wasn't why. 8 months later, one of your major clients was facing a regulatory investigation. An agency had begun asking about internal testing protocols on a product that had been on the market for 6 years. You knew some of what the internal documents showed. Not everything. Enough. The man called before you called him. He said the investigation had a specific vulnerability. A career agency official who had been the original signatory on the product's approval was quietly unhappy with his current position. A well-timed endorsement from the right people, the kind of endorsement that moved careers, could shift the texture of the investigation significantly. Nothing improper. Just attention paid to someone who deserved it. Relationships that served everyone. You told yourself the official's record was genuinely strong. You told yourself you were simply doing what good lawyers did. Understanding the human landscape of a situation and navigating it carefully. You made 3 calls. The investigation changed shape over the following months. It didn't disappear. It narrowed, focused on peripheral matters, concluded with a consent agreement and no admission of liability. Your client sent a case of wine that cost more than your paralegal's first monthly salary at your old practice. You didn't drink it, but you didn't return it either. The man began calling more regularly. The requests were always framed in the language of professional assistance. Connections, context, strategy, nothing that any individual call could reduce to a crime. That was the architecture. You understood the architecture because you had once been the kind of lawyer who looked for it on the other side. Then a journalist called your firm's communications department. She was investigating the regulatory case. She had obtained internal documents through a source she declined to name, and she was asking the firm to respond to specific questions about the timeline of the agency official's career movement and its relationship to the investigation's narrowing scope. She was right about the timeline. She had it exactly. The man called that evening. He said the journalist had a history. He said a complaint had been filed with her publication 2 years ago. A source dispute, substantive enough to have gone to her editor, resolved in her favor but still on the record. He said there were people who could speak to a pattern. He said her editor would have to take it seriously. You had a daughter who was 26. She worked for a nonprofit. She came home for dinner sometimes and talked about her cases the way you used to talk about yours, fast. Certain that the work mattered. Certain that the truth, deployed correctly, could change something. You thought about her while the man was talking. You told him no. He said that was a choice with consequences. That the timeline the journalist had wasn't the only timeline. That there were records of your involvement in the regulatory matter that could be read more than one way. That you should think carefully. You told him you'd already thought. The story ran 3 weeks later. Your name was in it. Not the central figure, but present, with enough specificity to require a response. The firm placed you on administrative leave pending an internal review. 4 clients requested new counsel. The Bar Association opened a preliminary inquiry. You sat in your kitchen the night the story ran. The framed check was still on the wall above your desk in the office you no longer had access to. The settlement for the 11 families. The Medical Monitoring Trust. You called the journalist. You told her you would talk. Not for a deal with the bar, not for anything. Just because the full record deserved to exist somewhere, and you were the only person left who could give it to her. She was quiet for a moment. Then she said she appreciated you calling. You thought about the storefront office, the waiting room without enough chairs, the printer that jammed, the people who came anyway because your number was on a flyer and you picked up. You had stopped picking up a long time ago. Maybe that wasn't the last thing that was true about you. Maybe it was just the thing you had to find your way back to. Not the cases, not the wins, just the picking up. You didn't know if you could, but for the first time in years, you weren't pretending you already had.